Hello, I'm Abby, and this is my friend Jeannie. Today, we'll be talking about the court's ruling in the case Edwards versus Vannoy.
On Monday, May 17, 2021, the court held that its previous ruling in the case Ramos versus Louisiana, banning non-unanimous jury verdicts, doesn't apply to previous cases decided before Ramos.
For context, before the court's decision in Ramos in 2020, state criminal trials didn't require a unanimous jury to convict a person for serious crimes. Instead, the bar was a 10-2 vote. That standard was established by a 1972 ruling in the case Apodaca versus Oregon.
This didn't mean states couldn't pass their own laws requiring a unanimous jury. In fact, many of them did. Louisiana and Oregon were the only two states that made their requirement a 10-2 vote. This case began in Louisiana.
Right. In 2010, a jury convicted Cedric Edwards of armed robbery, kidnapping, and rape by a 10-2 vote. Edwards challenged the verdict, arguing that he had a constitutional right to be sentenced by a unanimous vote.
And the Supreme Court decided that very issue in 2020, ruling that the Sixth Amendment does give people the right to a unanimous jury in both state and federal courts. As a reminder, that's Ramos versus Louisiana. Now, Edwards' case will decide whether Ramos can be applied retroactively, meaning to previous cases decided before the court's decision in Ramos.
To decide this issue, the Supreme Court had to consider two factors. First, did Ramos establish a new procedure for criminal cases? And second, does this new procedure qualify as a watershed rule?
If you picture a watershed, it's a ridge of land that separates rivers and streams, diverting water so that it flows in different directions. That's kind of what the watershed rule is like. If a new criminal procedure creates such a radical change that it changes how the law is inherently applied, then it's like a watershed. You can picture the water flow like different decisions in cases as a result of the new criminal procedure.
While watersheds might not be too rare in an ecosystem, they're very rare in the legal field. In fact, they're so rare that the court has never applied this exception in the 32 years since it was established. That was in the case Teague versus Lane. In order for Ramos to be applied to past cases, it would need to meet the watershed rule.
Now, let's move on to the court's ruling. In the 6-3 ruling, the Supreme Court held that Ramos can't be applied retroactively. While it does meet the first factor and establishes a new criminal procedure, the court determined that it doesn't meet the watershed exception.
Let's look into the court's reasoning. To do this, we'll be taking a look at the majority opinion, written by Justice Brett Kavanaugh. First, did Ramos establish a new procedure? Kavanaugh wrote that it is a new procedure because it's not something established by past cases. Ramos actually overturned Apodaca, a case that was nearly 50 years old.
Next, why didn't Ramos meet the watershed exception? Well, the court looked at past cases similar to Edwards and found that they'd never applied the watershed rule. Kavanaugh reasoned that since the court didn't apply this exception to these cases, they shouldn't do so now.
Kavanaugh also questioned the feasibility of retrials for all the people convicted by non-unanimous juries before Ramos. He wrote that retrials for decades of convictions would require significant state resources. Also, witness testimony could be faulty, and it could be painful for victims, testifying again decades after the fact.
The court didn't stop there. No case has ever met the watershed rule since it was established, and the court concluded it's likely any further procedures are going to satisfy this rule. So they decided to overturn it.
Okay, so no watershed. Chief Justice Roberts and Justices Thomas, Alito, Gorsuch, and Barrett joined the majority opinion. Justice Thomas and Justice Gorsuch also wrote concurring opinion.
Justice Thomas agreed with the court, but held that it could have reached the same decision through another route, by applying the Anti-Terrorism and the Effective Death Penalty Act of 1996, known as AEDPA. Justice Gorsuch argued that the retroactive test in Teague, that's the watershed rule, doesn't align with court rulings prior to the 20th century.
Now for the dissent. Justice Elena Kagan wrote the dissenting opinion, joined by Justices Stephen Breyer and Sonia Sotomayor. Kagan wrote that certain factors, like overturning Apodaca and also the reputation of a unanimous jury as a bedrock of fair court systems, could indicate that Ramos actually does meet the watershed rule.
Also, Kagan wrote that even if the court hasn't found a case that's met the watershed rule since Teague, that doesn't mean the rule won't need to be applied in the future.
The court's decision affects those convicted in Oregon and Louisiana, the only two states that didn't require unanimous convictions prior to Ramos, as well as those in Puerto Rico. However, Louisiana legislation now permits those like Edwards to apply for post-conviction relief. And, thanks to Ramos, all future criminal cases will be decided by unanimous jury verdicts.
And oxygen is the final electron acceptor of the electron transport. Whoops, I was thinking about my science test. Which reminds me, I've got to go study.
I think that's a good idea. But anyway, that's a summary of the court's ruling in Edwards versus Vannoy. See you next time.